For our next story, we have a follow-up on a prior story. So we did a audio react video where we reacted to the Fourth Circuit Court of Appeals eviscerating an attorney representing some cops who had conducted a no-knock warrant, and a no-knock warrant when they didn't have permission to do a no-knock warrant. The warrant said they had to knock and announce. They didn't do those things. And this article goes a little bit into why that is. So we're going to read a little bit of the article, and then we're going to read the underlying case that the article is talking about so we can understand why this might come to be. So let's get started with that. In 2006, the Supreme Court ruled in a case called Hudson v. Michigan that evidence seized during raids in which police violate the knock and announce requirement is not subject to the exclusionary rule. So the exclusionary rule is a rule that says that if you have illegal evidence, you can't use it in court. It's to exclude it. So if the police obtain evidence illegally, you bring a motion to exclude, a motion to prohibit it from being introduced. But the U.S. Supreme Court said here that if the rule you're violating is this knock and announce requirement, then the exclusionary rule does not apply. The evidence comes in anyway. So that's what they're talking about. The rule states that evidence seized during a search that violates the Fourth Amendment can't be used against a suspect in trial. It's meant to deter illegal searches. Writing for a 5-4 majority, Justice Antonin Scalia said that although the knock and announce rule is indeed a part of the Fourth Amendment, excluding evidence from raids in which police failed to abide was too extreme a remedy for such a minor violation. Instead, Scalia argued that new professionalism in police departments around the country, as well as a trend towards more internal discipline at police agencies, were sufficient to deter the police from violating their requirement. Blue, who was one of the cops, and the city of Myrtle Beach recently changed Blue's story. Once other jurisdictions had settled with Benton, the guy who was shot, Blue argued he shouldn't be held liable because it was Guess who violated the knock and announce rule. Guess is the name of another cop. Once Guess had hit the door with a battering ram before the officers had satisfied the knock and announce rule, Blue said in court following, the raid was compromised. That created exigent circumstances for the no-knock entry. Blue had no choice but to enter because the suspect was aware the police were outside. That's a pretty brazen and convenient defense. It's essentially stating that once a fellow officer violated the rights, Blue had no choice but to violate them as well. And since Guess's police department had already settled with Benton, putting all the fault on Guess gets Blue and Myrtle Beach off the hook without subjecting other officers to more liability and without risking risk of them objecting. It's also a blatantly dishonest defense. As mentioned earlier, Blue's previous statements directly contradicted his new narrative. He previously explicitly said that Guess had announced and knocked and announced. Somehow, it gets worse. As it turns out, the 15th Circuit's Drug Enforcement Unit, so here the 15th Circuit refers to an administrative agency within the state of South Carolina, not to a federal court system, so it's a little bit misleading title. But it just refers to a multi-jurisdictional entity. So there's many of these, and this happens to be the 15th one. And Drug Enforcement Unit is the name of the agency that conducted this particular raid. As it turns out, the 15th Circuit's Drug Enforcement Unit does not have an official policy on how to serve search warrants. Personally, I would think that's important, but the DEU does not agree with me. The DEU manual has policies on nearly every other aspect of narcotics policing, but it does not have a policy for serving search warrants. Warrant service is arguably the most dangerous and perilous part of drug policing. Officers are breaking into private homes with a battering ram and then storming the houses with guns. These raids are extraordinarily volatile and leave only a thin margin for error. According to a profile by a local NBC affiliate, the DEU agency conducts about 150 such raids in a year. Given that DEU agents testify that nearly all the raids were done without proper knock and announce warrants, and they hadn't bothered to obtain a no-knock warrants in almost all of them, they said such a warrant was obtained in less than 1-2% of the raids, it's fair to say that the DEU has been routinely violating South Carolina's Fourth Amendment rights and carelessly subjecting them to violence along with other unnecessary risks of injury or death. But you could also argue the DEU is not particularly concerned about the safety and rights of the community it serves. Here, for example, is the emblem the task force uses on the cover of its operational plan for the raid. So this is a logo that was created by a government agency. This is a government agency logo. So it says Drug Enforcement Unit in some sort of horrible font from like Windows 95, 15th Circuit, serving our community, one drug dealer at a time. And then it has a picture of a marijuana leaf, on top of which is a lightning bolt, on top of which is some sort of dagger, on top of which is a skull and crossbones. So that's just, super interesting, and again, represents a logo of a governmental agency. So this is a thing that exists. That's just super interesting. A pot leaf overlaid with skull and crossbones, a sword and lightning bolt doesn't seem like the sort of emblem you'd adopt if you're particularly concerned about rights and safeties of your constituents. What happened to Benton is extremely predictable product of the failures, culture, and mindset of this crime's drug enforcement unit, and yet to date, state officials won't even concede that this was a bad outcome, much less to do anything to prevent it from happening again. Citing the South Carolina Law Enforcement Investigations Division's investigation, South Carolina Solicitor Kevin Brackett cleared the officers of any wrongdoing within a few months. In the 3 years since the raid, no officer involved has been disciplined, even internally. Nor has any officer been asked to undergo any additional training. No policies have been changed. The DEU never even bothered with its own investigation or even an after-action examination to determine what went wrong. This, of course, is just one police unit in one state. Both before Hudson, the Supreme Court case, and 12 years since, we've seen a multitude of stories across the country of other drug task force, seemingly operating without much oversight or scrutiny. In Hudson, the Scalia-led majority determined that a knock-and-announce violation was a minor affront to the Fourth Amendment. Benton's injuries would certainly suggest otherwise. He's been paralyzed, incidentally, as with the multitude of injuries and deaths that were documented from the site that resulted from other forced entry raids. The majority in Hudson also ruled that internal discipline, police professionalism, and civil liability were sufficient to ensure police officers followed this knock-and-announce rule. With Bill Knowles, the commander of the DEU, asked in a deposition why none of the officers were disciplined after the Benton raid, he replied, they didn't do anything wrong. Super. So what we've learned by reading this article is that it's not so much that the DEU violated the Fourth Amendment as it is their standard practice and policy to violate the Fourth Amendment. So to understand how this came to be, let us read the Supreme Court decision that they refer to in the article so we can understand a little bit more about how this all came to be as a matter of law. This is a 2006 decision from the United States Supreme Court. It's titled Hudson v. Michigan and deals with exactly this issue. So let's read what the Supreme Court had to say. Detroit police executing a search warrant for narcotics and weapons entered petitioner Hudson's home in violation of the Fourth Amendment's knock-and-announce rule. The trial court granted Hudson's motion to suppress evidence seized, but the Michigan Court of Appeals reversed on an interlocutory appeal. Hudson was convicted of drug possession. Affirming, the State Court of Appeals rejected Hudson's renewed Fourth Amendment claim. Held, the judgment is affirmed. Justice Scalia delivered the opinion of the court with respect to parts 1, 2, and 3, concluding that the violation of the knock-and-announce rule does not require suppression of evidence found in a search. Because Michigan had conceded that entry here was a knock-and-announce violation, the only issue is whether the exclusionary rule is appropriate for such a violation. This court has rejected indiscriminate application of the exclusionary rule, holding that it's applicable only where its deterrent benefits outweigh its substantial costs. Exclusion may not be premised on the mere fact that constitutional violation was a but-for cause of obtaining the evidence. The illegal entry here was not the but-for cause, but even if it were, but-for causation can be too attenuated to justify exclusion. Attenuation can occur not only when the causal connection is remote, but also where suppression would not serve an interest protected by the constitutional guarantee violated. The interests protected by the knock-and-announce rule include human life and limb, because an unannounced entry may presumably provoke violence from a surprised resident. Yeah, I would think so. Property, because citizens presumably would open the door upon an announcement, whereas forcible entry would destroy it, and privacy and dignity of the sort that can be offended by sudden entrance. But the rule has never been protected of one's own interest in preventing the government from seizing or taking evidence described in a warrant. Since the interests violated here have nothing to do with the seizure of evidence, the exclusionary rule is inapplicable. The social costs to be weighed against deterrence are considerable here. In addition to grave adverse consequences that excluding relevant information always entails, the risk of releasing dangerous criminals imposes such a massive remedy would generate a constant flood of alleged failures to observe the rule, and the claims that the asserted jurisdiction for the no-knock entry have inadequate support. Another consequence would be police officers refraining from timely entering after a knocking announcing, producing preventable violence against officers in some cases, and destruction of evidence in others. Next to these social costs are deterrence benefits. The value of deterrence depends on the strength of the incentive to commit the forbidden act. The incentive is minimal here, when ignoring knock and announce can realistically be expected to achieve nothing but the preservation of evidence destruction and avoidance of life-threatening resistance, dangers which suspends the requirement, whether there be a reasonable suspicion they exist. Massive deterrence is hardly necessary. Contrary to Hudson's argument that without suppression there would be no deterrence, many forms of police misconduct are deterred by civil rights suits and the consequences of increasing professionalism on police forces, including a new emphasis on internal police discipline. Well, my friends, I think this is an example of where theory and practice depart. In theory, I think Justice Scalia was probably right. In practice, not so much, because as we learned from reading the article, in theory, while there should be professionalism and internal enforcement and all the rest, none of these officers were disciplined, and this is a thing that they have been doing as a matter of routine practice, and they have no intention of stopping. So the only thing that would really stop them is the exclusionary rule. If they knew they couldn't bring the evidence in, maybe they'd be less inclined to do this. Now, it's true that you can sue the officers involved, but we've seen how hard that is. So the fact that you have this civil remedy in going after them monetarily is not that much of a disincentive either, because it takes so long to do, and so many people will not avail themselves of it because it's so costly that in a lot of cases it wouldn't deter them at all. So I think this shows some of the weaknesses sometimes that can be found in a theoretical approach. Here, in theory, there makes a lot of sense. And in theory, the police would enforce themselves better. In theory, the civil defense would be enough. But in practice, South Carolina's Drug Enforcement Unit and apparently other units around the country are routinely violating judges' orders which say knock and announce, and are not doing that because they can just bring in the evidence anyway. So why would they stop? Hasn't stopped them, so perhaps there's an opportunity for the U.S. Supreme Court to examine its decision in light of renewed facts on the ground, which is a classic grounds of re-examining decisions to undo a Supreme Court decision. So perhaps they will take advantage of that and look at the facts and say that the facts did not play out the way that they thought. So that is the state of the law where it exists, and that's enough for our story for today.